All right, everyone, welcome back to another episode of Bankruptcy with Ben. In this video, we're going to get into the bankruptcy filing of Johnson & Johnson. And this is not Johnson & Johnson's first run-in with bankruptcy. It's not their second run-in with bankruptcy. It's their third run-in since 2021. And for those of you who followed us in the Purdue Pharma series, we're going to see there's actually a lot of similarities between J&J's current filing and the Purdue filing. There's also some critical distinctions. Purdue Pharma, if you'll recall, was faced with a deluge of thousands and thousands of lawsuits from all over the country, alleging that the OxyContin drug that was produced by Purdue Pharma, which was an opioid, helped in part, at least, to fuel the opioid epidemic, which caused untold destruction, lots and lots of overdoses throughout the country. Unfortunately, many, many deaths and many lives destroyed. And Purdue Pharma wanted a way to uniformly resolve all the lawsuits under one umbrella. And so they filed for bankruptcy. J&J similarly has been faced also with about 60,000 lawsuits from all over the country. J&J was manufacturing a talcum-based baby powder product. And there were allegations that this product caused ovarian cancer. Obviously, J&J denied it, but they've discontinued that product anyway. J&J, however, they had a bit of a different issue than Purdue. And that is that they had these lawsuits, but they were still a fairly healthy company. Don't forget, back in 2021, J&J was one of the three large manufacturers of the COVID vaccine. And so they did pretty well. And so they were a relatively healthy company. But they wanted to have a way to deal with all these lawsuits. So what did they do? They did a controversial maneuver, which some people may call it clever, others may call it underhanded, depends how you look at it. But they took advantage of a little-known law in Texas, which has now since become very well known because of Johnson & Johnson's use of it. It was called the Texas two-step. And what they did was they split their company into two. And they created one entity, and they said, this entity is going to be responsible for all the liabilities of the company. So basically, they saddle all that company with the debt of the company. And the other company, the regular J&J parent company, that no problem, healthy company, we're just going to continue to do business as normal. Why did they do this? Because they wanted the benefits of the bankruptcy, but not the burdens of bankruptcy. What does that mean? Well, one is in PR. They don't want to say that Johnson & Johnson filed for bankruptcy. It's just bad PR, despite the fact that they have bad PR from all the litigation that's going on, from this being their third attempt at bankruptcy. Nevertheless, they think that putting the whole company into bankruptcy will be even worse. Another reason, don't forget, in Purdue Pharma, one of the issues was that the Sackler family wanted a release from liability. When the Supreme Court struck down that provision of the proposal, which would have essentially indemnified the Sacklers from all future opioid-related litigation, the Supreme Court said specifically that when an individual files for bankruptcy or entity files for bankruptcy, they're putting forth all their assets as being available for distribution to the creditors. The Sacklers weren't doing that. The Sacklers were not putting forth all their assets. They said, okay, we're going to contribute $4 billion, $5 billion, $6 billion. But that was a drop in the bucket for the Sacklers. They had much more money available. And the Supreme Court said you cannot get a discharge, which would have been the release, if you do not put forth all of your assets into bankruptcy. Johnson & Johnson, they seem, among other things, to want to avoid having to put forth all the assets of J&J into bankruptcy, because then that could severely hamper the company. And obviously, no one wants to put forth more assets than they have to. So when they do this Texas two-step, they say, okay, the assets of the company, the good parts of the company, that's not available. Creditors can't touch that because that's not in bankruptcy. The bad parts of the company are in bankruptcy. Okay. But then what's the purpose? How do they accomplish anything if it's just a debt-laden company? So what they did is they did another maneuver. They said, we'll have a funding agreement where Johnson & Johnson is going to provide funds from the Johnson & Johnson parent company to this new entity that was spun off, which in this case is called Red River Talc. And that entity will be able to use the money they get as part of this funding agreement to pay off the creditors. So that's the way they wanted to structure it. They filed in 2021, ran into all sorts of problems, case got thrown out. They filed in 2023, case ran into all sorts of problems, got thrown out. Try again. That's the motto of J&J. So they now just last week filed a third time. Key difference though, this third bankruptcy is what's called a prepackaged bankruptcy. And what that means is they reached a deal with their creditors in advance of the bankruptcy. So normally when you go into bankruptcy, you try to negotiate a deal with your creditors within the context of the bankruptcy itself. Here, they said, we reached an agreement already, and now we just want the bankruptcy court to give it our blessing. There are two problems, though. One problem is that it was not unanimous. They did not get 100% of all the creditors to agree. They got a very large percentage. It was somewhere in the neighborhood of about 80 to 85%. So very substantial. And as a bankruptcy attorney myself, I can tell you that if I went into bankruptcy with consent from 85% of the creditors of the company I represent, I think I'm already off to a pretty good start. So I don't blame them for trying. But a company of this massive size and scope, which is going to generate so much attention, you have to be careful. And the minority creditors that did not agree, as we'll see, are objecting to this bankruptcy. And not only that, they forgot about another very important party, and that is the United States Trustee's Office. As we've discussed, the U.S. Trustee's Office is a wing of the DOJ, and their job is to be the bankruptcy watchdog. In other words, they want to make sure that everybody kind of sticks to what they're supposed to do and not play around, not play games, but do what they're supposed to do and follow the bankruptcy rules, follow the bankruptcy procedures. Don't mess around. Just do everything by the book. That's their goal. In Purdue Pharma, the U.S. Trustee's Office was one of the driving forces behind taking the case all the way up to the Supreme Court, which ultimately struck down their proposal. So if Johnson & Johnson was paying attention to Purdue Pharma, they should have known in advance that there's a very good chance the U.S. Trustee is not going to like what they're doing here. So that's the background. Without further ado now, let's look into the actual pleadings and see what is actually going on. In this case, we're going to actually start with what's called an adversary proceeding. An adversary proceeding is simply a lawsuit that's filed within the context of the general bankruptcy case. So a bankruptcy case is not necessarily like a traditional lawsuit, right? A traditional lawsuit has a plaintiff and a defendant. A bankruptcy is somewhat of a special proceeding, which is started with a petition where a company or an individual says, bankruptcy court, I need your protection and protect me from my creditors. But it's not necessarily a lawsuit, but it puts a stop to all outside lawsuits. So creditors can no longer sue them. The same token, a debtor can't go ahead and just sue their creditors or other parties outside of bankruptcy court because that defeats the purpose of the bankruptcy. So there's something within the context of the bankruptcy proceeding called an adversary proceeding. And that is when a lawsuit is started under the context of the bankruptcy proceeding. And it's going to be under the supervision of the same bankruptcy judge, and all the regular parties who are participating in the bankruptcy will also have an opportunity, if relevant, to participate in this lawsuit. So in this case, Johnson & Johnson, or their affiliate, the subsidiary, they're actually the ones that started this lawsuit. So let's take a look. Okay. So it's called Red River Talc. So Red River Talc is Johnson & Johnson. So don't get confused. Say, who is Red River Talc? Red River Talc is a subsidiary of Johnson & Johnson. They were spun off. This was a new company created under this Texas two-step law. And they're responsible now for all the debt of Johnson & Johnson, but they do not have the assets of Johnson & Johnson. Now, you can see here, it's Red River Talc LLC. And that is how bankruptcy captions look. It's In Re, and then the name of the party that's in bankruptcy. Now, underneath, you have Red River Talc LLC, which is the plaintiff, and they're suing. Who are they suing? Those parties listed on Appendix A to the complaint, and John and Jade knows 1 to 1,000. Okay. So it's very unusual, but what happens is when you have a lot of different parties that you want to sue, you don't have room in this little space here, especially if they're naming 1,000 different parties to list everybody. So you're just going to say the list is already there and it's attached separately. Now, what do they want? They want a ruling that the automatic stay applies to certain actions against non-debtors. In plain English, what does this mean? Again, if you remember, Red River Talc was not sued by anybody. Johnson & Johnson was sued. Individuals related to the company were sued. Other affiliates of Johnson & Johnson were sued. Some of the insurance companies of Johnson & Johnson were sued. But Red River Talc was never actually sued. So the whole purpose of the bankruptcy is to provide one forum to put a stop to the lawsuits. How is Red River Talc, which is not Johnson & Johnson, how are they going to manage to put a stop to lawsuits that they were not even a named party in? And that's why they filed this, because they're saying, okay, bankruptcy court, we know we're not a party to those cases. But even though we're not a party to those cases, for the reasons that we're going to say, which is essentially that they're all related, we think the bankruptcy court should rule that this bankruptcy stay applies to all the Johnson & Johnson related litigation and all the litigation related to this talc powder, this talc-based baby powder product. So let's run through some of the background. So as we discussed, it's a prepackaged plan to resolve all current and future ovarian cancer claims related to the Johnson & Johnson baby powder. Now, what do they want? They want a declaration that the automatic stay extends to stop all these other cases. They listed them in Appendix A, and Appendix A, again, just lists all the different lawsuits that are going on. And these are the parties that they want to be protected from this litigation. Now, who are the parties? The debtor, Red River Talc, is a Texas limited liability company, and that was one of the reasons for the controversy is that Johnson & Johnson did not have any corporate headquarters in Texas, yet they chose Texas as the place to file for bankruptcy. So what is the background of this case? Cosmetic talc litigation against the debtor, its predecessors, and the other protected parties has focused primarily on Johnson's baby powder as a purported cause of ovarian cancer. So, again, what are the types of claims that have been asserted against Johnson & Johnson? Claims alleging ovarian cancer arising as a result of talc exposure, and claims alleging other types of respiratory cancer or asbestos-related diseases. Now, again, they say, oh, it's a safe powder, been used by millions of consumers worldwide. Amazing. We stopped it in 2023, not because there was anything wrong with it, but because of misinformation about the safety of it. And that's why they stopped it. So, okay, obviously, they're not going to concede liability. They're not going to ever concede they did anything wrong. How did all this litigation start? Prior to 2010, there were only a small number of isolated lawsuits that alleged claims relating to Johnson's baby powder. However, there was a 2013 case where a jury found for the plaintiff and said, yes, this talc powder, this talc-based baby powder, caused ovarian cancer. Even though they did not award any damages, that led to the floodgates being opened. And in 2014, they got 46 lawsuits. And then in 2017, nearly 5,000. And then in the years that followed, tens of thousands cases filed all over the country, resulting in what's called multi-district litigation, which they say I'll describe below. That we're not going to discuss that in this video, except to say it's a form of combining various litigations into one forum. As of the petition date, which is the date the bankruptcy was filed, more than 60,000 plaintiffs are claiming ovarian or other cancer claims against the debtor. Again, it's a bit of a misnomer because they're not claiming it against the debtor. They're claiming it against the debtor's parent company. But okay. Particularly with respect to allegations of ovarian cancer caused by asbestos exposure, ovarian cancer-related talc litigation is anticipated to continue for decades more, as is the extraordinary cost of defending and resolving tens of thousands of expected claims. So that's why they had to file. All right, let's see what else we want to get into here. Now, the debtor's ultimate responsibility for all debtor talc claims. So the debtor traces its roots back to Johnson & Johnson baby products, a New Jersey company incorporated in 1970 as a wholly-owned subsidiary of J&J. The debtor traces its roots back to Johnson & Johnson baby products, a New Jersey company. So again, that's part of the controversy, is that they're a New Jersey company and they filed in Texas. So everyone is saying, what on earth is a New Jersey company doing filing for bankruptcy in Texas? Well, Johnson & Johnson, the reason they're doing it is because they're taking advantage of the Texas two-step law. which is not available to it in New Jersey. Now that gets into forum shopping, which is a whole other kind of controversy surrounding bankruptcy, where essentially what's being done is corporations will sometimes literally do nothing more than set up a PO box in a certain jurisdiction because they think that that jurisdiction, which is often Texas, will be more favorable to them than the actual state or county where they're headquartered. So they did something to give themselves some connection to Texas, and then they did this Texas two-step and filed for bankruptcy in Texas. J&J was incorporated in 1887, and they first began selling baby powder in 1894, so for a long, long time. So that's some of the background and the history of J&J and the history of the baby powder. This here is just a timeline of all the transactions. When did they begin selling it? What are the other divisions of J&J all the way up to 2015? Again, this gets into more about the history and insurance coverage. Again, I just want to hit some of the main points just to give you the basic idea of what they're trying to do and what's going on. Now we get into a little bit more of the prior bankruptcy. On October 14th of 2021, LTL commenced the 2021 Chapter 11 case. After transfer of the case to New Jersey Bankruptcy Court, the case was two plaintiff law firms, meaning two of the personal injury firms that were representing the claimants. They went to dismiss the 2021 Chapter 11 case. So LTL was another one of these subsidiaries that was created by Johnson & Johnson before the creation of Red River Talc. The New Jersey Bankruptcy Court said, no, everything they did is fine, and they denied the motion to dismiss and said, you can stay in bankruptcy. Then it went up to the Third Circuit Court of Appeals, and they reversed, and they said, no, the case should not be here. Get rid of it. It has to be dismissed. One of the reasons, which it doesn't directly discuss here, but one of the reasons that the Third Circuit Court of Appeals dismissed it is they said that LTL was kind of a fake company, and Johnson & Johnson was a healthy company. And Johnson & Johnson, which was essentially the real company that was driving this bankruptcy, was not in financial distress. And if you're not in financial distress, you cannot be in bankruptcy. So, in other words, if you don't go to the hospital if you're not sick. So bankruptcy, maybe it's not the best way to look at it that you're sick, but you need some kind of distress. You don't go to the doctor unless you're going for a regular checkup. You don't go to the doctor, you don't go to the hospital unless you're sick. And the Third Circuit said, essentially, you have to be sick. You can't be healthy. And Johnson & Johnson is a healthy company. After dismissal of the 2021 Chapter 11 case, on April 4th of 2023, LTL, meaning Johnson & Johnson, they commenced the second Chapter 11 case, again in New Jersey. So first they started in North Carolina, got transferred to New Jersey. Now they said, okay, we'll go to New Jersey right away. Now the old funding agreement, and again, the funding agreement, they said Johnson & Johnson will pay for the liabilities of LTL. Now there's a new funding arrangement, and they're thinking, okay, this new funding arrangement will be sufficient for us to show whatever it is that the courts want us to show to stay in bankruptcy. Creditors were not happy. The talc claimants and various other parties, again, moved to dismiss it. There was essentially a 4-day trial on the dismissal, and the bankruptcy court concluded again that LTL lacks sufficient financial distress necessary to avail itself of bankruptcy relief. And again, they said the Third Circuit already told us that you need to be in distress to use bankruptcy. And whatever new gimmicks you're using, it's not sufficient. It's still not good enough to be in bankruptcy. Get out of here. Go. You're gone. Okay. But did that dissuade Johnson & Johnson? Absolutely not. They filed again. New funding arrangements. In 2024, they did another restructuring, and they entered into a new funding agreement with New Holdco, which is some other new company, as a payor, meaning they're splitting it off again a little bit from Johnson & Johnson. So they created another little middleman, and then Johnson & Johnson pays the middleman, and this middleman now pays the debtor, which is Red River Talc. And now this new company has to provide funding for the debtor to use to pay back all these personal injury claimants. Now, what do they want? Nature of the relief. They want so this is important. They want what's called declaratory relief. Declaratory relief is when you're not necessarily asking for money. You just say, court, we need you to tell us what the law is. Because if you don't tell us what the law is and who's right and who's wrong here, that's going to really kind of, mess things up. For example, if let's just say, just any classic example of declaratory relief. I have a case now where a contractor is being sued by a construction worker who was doing work on a property and got injured. The insurance company of the contractor now comes in and sues the contractor for what's called declaratory relief. They say, court, give us your blessing that we do not have to cover this claim, and we're not obligated to defend them. We're not obligated to pay them any money. So they're not saying that we want you, contractor, to pay us money. They just want a ruling from the court. So what is the ruling that Johnson & Johnson wants here? It's that all these other parties, continuation and commencement of debtor talc claims against the protected parties, which are unequivocally efforts to recover on claims against the debtor, are automatically stayed. Again, the protected parties are the parent companies of Johnson & Johnson. The parent companies of Red River Talc that are being sued, individuals that are being sued, and insurance companies that are being sued. And they're saying all that is related to the same unit of claims against Red River Talc, which again, it's not really Red River Talc because Red River Talc was not actually sued. But that's the argument they're trying to make. All right, so that's the heart of it. Let's just see if there's anything else that's worth noting. It goes through, the factors of when you can get an injunction and all that. That's pretty much the heart of it. So, to quickly recap, we'll dive into, later on, and we'll dive into more of the claims that are being asserted. This is, I think, a fascinating saga because now it's their third attempt at getting the benefits of bankruptcy and not the burden. Many, many, many people think it's not fair. Many people maybe think it's not fair, but are going along with it anyway because they'd rather get paid now than face some uncertainty in the future. So we'll stay monitored. We'll see how this goes. All this is brand new filings. Just hit the docket. If you like the video, remember, comment, like, subscribe. Until next time, we will stay tuned.